Uh,
Ooh, that's new.
all right, everybody's been notified now. Um, If you have any questions as we go along, type them in the chat room. Chris and I will be monitoring those, and we'll get those to people. We'll get those out as soon as possible. And Chris, I will turn it over to you.
Thanks. It's a real treat and a real pleasure. We do want to thank Natch Grays for being with us tonight. As he did mention, he is here on short notice, coming in for another member of the team from the New Hampshire Municipal Association, so we're especially appreciative. He is the General Services Counsel for that organization. In that role, NH provides both legislative and legal services to NHMA's member municipalities. Before joining NHMA, NH was the prosecutor in Northern Grafton County. He received his BA from Clark University in Worcester, Massachusetts, and his JD from the College of William and Mary in Williamsburg, Virginia. And I must say, for this group, it's probably also interesting, and I hope you don't mind me bringing up or reminding folks that you're a carnivorous plant collector. You have a terrific blog about these plants, and I'm thinking there must be some way we can tie you into this group again to give us a talk about bogs in the wintertime and what's going on there. That could be something interesting to this group. And
I'd love to do so. It would be a nice change of pace from legal stuff.
Good. Well, thank you very much. And I'm sure that people are as interested or need to know right now the right to know law, governmental meetings, and your information tonight. But we will not forget about the other side, NH, with the carnivorous plants. Thank you.
No problem.
How do I think they're related?
Well, everybody has the right to know about carnivorous plants, so you know. As mentioned, and thank you for the introduction, Chris.
Sure.
So all of you who are, you're all members of your municipalities, and I'm happy to say all of your municipalities are members of NHMA. So you can certainly give me a call at any time while I'm at work, or send me an email. And I'm happy to talk with you about the law or carnivorous plants, whatever your preference is. So just generally to let you know what we do at the Legal Advisory Services at NHMA, there's some things that we do, which is, we provide general legal advice, and there's some things we don't do that we often get confused for. Most often we don't settle disputes inside municipalities. So if your select board's giving you a hard time, we can't solve that for you. That's gonna have to be somebody else. But we don't do things like document review. That's very detailed. That's something that your counsel for your municipality would do for you, whether agreements or drafts or any of that. We often get asked, do we have any sort of templates for whatever the municipality wants to do, ordinances, etc. We don't actually have a repository of those. It would probably be a good idea to have one, but we don't have the staffing capacity to review those and make sure that they're valid. And I know that oftentimes when we get asked, people want to be able to rely on the advice they're giving, and simply put, we just don't have enough people because it's just me and Steve providing legal advice. And our goal is to have a response to you within 48 hours. We don't always make that, especially around the holidays. People have vacations planned, but that's generally our goal, is to try to get your response within that time period. So that's us. So let's move on to you and the right to know law and governmental meetings. We do another program as well about governmental records, but I think it's really important to understand meetings, and I did put a little bit of records in there at the end because there are some things that just come up during meetings that you might wonder whether it qualifies as a record or not, whether it's something that someone might be able to make a right to know request about. So as far as what we're going to cover tonight, we're really covering 4 areas. What is a meeting? What is not a meeting, which is known as a non-meeting? What are the requirements for holding a proper meeting, and how to hold meetings virtually? Because even though hopefully everyone who wants a shot has gotten one. There are still, areas of concern with COVID, and it's important to keep people informed. And one of the things we've certainly seen over the last year, and we've seen a lot of support at the municipal level for, is remote meetings and continued remote meetings, because it's so easy just to assemble people from across the state and have those and actually get things done. Unfortunately, the legislature disagreed with our position, so we did not see that enacted to law, hopefully next session. So the right to know law actually comes from Part 1, Article 8 of the New Hampshire Constitution, which states that government should be open. And if you're a history buff like I am, you'll know that the New Hampshire Constitution is one of the oldest in the country. And really this stems from the Stamp Act. And so before we were the United States, when we were all colonists, the Parliament, the British Parliament, instituted the Stamp Act, which was one of many acts the colonists didn't like. And one of the major problems, of course, was that not only did we not have representation in Parliament, but Parliament didn't tell us what they were doing. They just said, hey, by the way, there's a new tax. It's coming out next year. And so they didn't actually tell anyone what it was going to be. And one of the major issues that was part of the revolution was, well, if you don't know what the government is doing, how do you know if what they're doing is in your best interest? So that really is the basis for the right to know law, and probably how you should think about it when you think about, how it actually operates in modern day times. Of course, RSA 91A is much more recent. It was enacted in the 60s. Apparently the government was up to some bad stuff back then. I don't know, over in Vietnam and over there. And so at the federal level, there was, the Freedom of Information Act, and all of the states followed and passed their own laws as well. So we have to begin with, what is a public meeting? And there are really 4 elements to this. It's a quorum of a public body that convenes so it can communicate contemporaneously to discuss or act upon something over which it has supervision, control, jurisdiction, or advisory power. Something that body does. If a bunch of select board members get together and they want to discuss, somebody's holiday party, they're not discussing something over which they have, jurisdiction or control, unless the municipality is throwing that. So that's not going to qualify as a public meeting. Similarly, if all of you get together and instead of talking about, conservation commission matters, you're talking about something totally different. It's not something that you have control over or give advice on. It's not going to be a public meeting. So when we say quorum, we mean a majority of the membership. And you can't define it as more than a majority to circumvent the law, but there are other statutes that may apply. So there are cases where a quorum is going to be, such as a zoning board, it's going to be 3 out of 5. It's not going to be, and that's actually statutorily defined. Even though you would define it that way normally, there's just kind of this additional statute. And there are other sort of random statutes throughout. I'm not aware of any that apply to conservation commissions or committees related to conservation. And of course, we're talking about public bodies, right? And we're not talking about, private individuals getting together. We're talking about people who are representatives of the public. So it's legislative bodies, governing bodies, boards, commissions, committees, etc. And it's also subcommittees. So one of the areas that municipalities often get in trouble for is they might appoint a subcommittee, whether or not they mean to, and that subcommittee is actually going to be subject to the right to know law. So the example I like to use is Old Home Day, because most towns have Old Home Day. And it may be the case that you have a very active group of people in your town who always organize Old Home Day, and how they do that and how that organization interacts with your select board is going to determine whether or not that qualifies as a public body. So if it's just, a group of business owners who come together, they figure out what they want their plan to be, and then they present that to the select board. The select board never authorizes them, never says, oh, by the way, Nate is gonna, and his little group of people are gonna take care of this. We don't have to worry about it. We'll just wait for them to come present to us. That's not going to be a public body. But if the select board says, hey, Nate, you and your friends go organize a home day, come back to us and report, at that point, we become a subcommittee or an advisory committee. So it's sometimes a very hard distinction to make, but it is an important one to keep in mind because it's possible that in your role or your committee's role, you may accidentally appoint a subcommittee by authorizing or blessing some sort of action that some group of people are doing. So it's important to keep that in mind. And of course, that group of people has to discuss board business, and they have to discuss it in a manner that they can all communicate contemporaneously. And that's really the key, because while we can talk about board business and how broad that is, and the courts generally construe that very broadly, what's really key is that contemporaneous communication. So oftentimes boards will get in trouble where they decide they want to use some sort of electronic means of communication. If we all meet in person, it's pretty obvious we're having a board meeting. Hopefully at this point, if we're meeting on Zoom or something like that, it's pretty obvious we're having a meeting. We can see and talk to each other. And the problem is when you come to something like email, because an email, you can send an email to somebody and, I don't know if you're sitting on the other side and going to reply to me instantly. And if it happens that I send that to a majority of the board and then we start emailing back and forth, then we cross that threshold of having a meeting. And that's really the key. And we've actually seen a Superior Court case that say, that ability to communicate contemporaneously, that possibility of someone sitting on the other side of the screen is enough. So we really have to be careful when it comes to electronic communication. Well, let's talk briefly about what is not a meeting, or what's often referred to as a non-meeting. So it's a social or other encounter is going to be the most common thing you are going to encounter in your day-to-day activities. So, if you, for instance, if a quorum of you go and have a birding expedition, but you're not discussing things over which you would talk about as a public body, then you're fine. That's not a meeting. It's just a social encounter. Even if it's accidental because you're all birding as it happens in the same place. There are also some other things that apply. If you're part of a collective bargaining negotiation and strategy sessions, that's not going to be that's not going to be a meeting. If you're consulting with legal counsel, and by that I mean live consultation. So for example, you call me up and I'm on the phone with you and there's, your whole board is sitting there. And that happens sometimes. And you all are talking to me about whatever the issue is. That's not a meeting. It's a non-meeting, and that's separate from a non-public session. And there's the way that plays out is in terms of legal advice, because there is an exception under a non-public session for legal advice, is if you write me a question via email and I respond via email, and then you take that as a board and discuss it, you've entered non-public session to do so. Whereas if you want to talk with me live, that would be at a non-meeting. The other non-meeting situation is if you circulate draft documents. So for example, there's a bunch of federal money coming out and you want to write a letter to the governor and say, Governor, please direct some money from Gopher to, do some conservation work. And you appoint someone to write that draft document. Circulation of those documents to less than a quorum is not going to be subject to disclosure by the right to know law, and it's not going to qualify as a meeting either. But when you do have the situation of having a public meeting, you are going to have to give public notice. You're going to have to make that meeting open to the public, and you're going to have to take minutes. So as far as the notice goes, the default rule is 24 hours in advance to public places. One of those public places can be your municipalities or your governmental organization's website if you have one. Otherwise, use town hall, use the post office, use the library, public places. Facebook is not a public place, just so we're 100% clear on that. Any social media site, we're not counting that as a public place. There may be a more restrictive law that applies. So many times in the land use context, and if you're on a land use board, you'll see, it may require notice 7 days in advance, or it may require notice in a newspaper. Those are more restrictive laws. There is an exception to this 24-hour to public place rule, and that happens when you're meeting under an emergency. And we're going to go into that in a little bit more detail in a moment, because that is something that we are seeing more of now. But the short answer is that if you have a situation that's an emergency and you're meeting and you can't wait 24 hours to have that meeting, and you need to have that meeting right now, you don't have to give that 24 hours notice. You don't have to put it in 2 public places. You can just give the kind of notice that you can give. It may be the case that you're quickly posting that on wherever you're having the meeting, and putting that on Facebook or wherever the case may be. So I forgot to change this to past tense, but for the past 15 months, we had been operating under Emergency Order 12, which allowed remote meetings, and that's gone now. Like the rest of the emergency orders, there's no ability to, operate under any of those. But even though those are gone, you can still have a partially remote meeting. Importantly, even if you want a remote meeting, there has to be a physical location for the public to attend. And in most cases, a quorum of the board's going to have to be present at that physical location. But there's nothing that's going to prevent a board. There's nothing in law that's going to prevent a board from continuing to offer electronic access to the public. And so it's really important to think about board members and the public separately. You can't force the public to attend remotely, but, and I've heard this from dozens of municipalities at this point in time, there are plenty of people out there in the world who, for whatever reason, can't attend a board meeting, but they got really engaged during the pandemic. Maybe they were disabled, maybe they have young kids at home, maybe they're elderly, whatever the case may be, they really couldn't attend and can't realistically attend a board meeting in person, but they started attending during the pandemic. They want to be involved in municipal government, and they want to know what's going on. And certainly, keeping in mind the goal of the right to know law is to provide as much public access as possible. If it's feasible to continue using some sort of Zoom or YouTube stream or whatever the case may be, it's a good idea to do so. You're not required to do so, but it's a good idea just because you provide that greater access, and generally the public is very happy if you do so. Now let's talk about a couple ways that you can have board members participate remotely. And the first is just kind of a standard remote participation. So, if we're all on a board together and I go to Florida and I want to attend the meeting, if you have some sort of rule of procedure that says that members who are not able to be present can attend remotely, I can do so. I can call in, or I can connect via Zoom. And it's something you may allow or something you may not allow. It's totally up to each board. And in the minutes of that meeting where I'm attending remotely, I have to specify why my attendance is not practical. So I might say something like, I'm in Florida. And as long as I can hear everyone and everyone can hear me, and I'm identified in the minutes as being in a remote location, and we take our votes via roll call, everything's good. A quorum of the rest of the board is going to be present at whatever the location is, and just I'm going to be remote. And that's perfectly acceptable. It's something that isn't really too hard to accomplish. And I think most boards at this point are accepting of that, assuming you have some sort of call-in ability. Then there's the second option, which is the emergency provision. So some sort of emergency has to occur, that it's the chair or presiding officer is going to say, look, this is a crisis, and we need to deal with it right now. So the example I like to use is, if we're on a select board, Main Street washes out, it's a crisis. You need to have action immediately. You can't just allow people to drive off into the void. That's not good. You have to start the process of trying to block off the road and make sure everybody, is coming together to figure out what the plan is going to be to fix this. You still have to have a physical location for that emergency meeting, but a quorum of the board doesn't have to be present. The rest of us can be remotely. And if you think about it, maybe I'm in Florida, maybe the other board member that's on the select board with us might be on the other side of the washout. They can't get there. So, we're going to just call in. As long as everyone can hear and be heard, or identified as being remote locations, we're having our votes via roll call. That's perfectly fine. And again, in this situation, you don't have to provide your 24-hour notice. And there actually is a definition of emergency in the statute, and it's a situation where immediate or undelayed action is deemed to be imperative by the chairman or presiding officer, and that has to be recorded in the meeting minutes. So if you think back to COVID, you may have seen the COVID script that was written up by the AG's office. You might have been using it. That's basically what that filled in. Do you have any questions at this point?
Yeah, we have some questions that people have listed. One here from Paul. We occasionally appoint working groups to work on something. For example, come up with a plan for trail maintenance and ask them to report back to a regular conservation committee meeting, and we document their work in the minutes of a regular meeting. Am I going to go to jail?
So we're going to talk about enforcement of the right to know law at the end here. Going to jail is not one of the possibilities. So, it is something that, someone who is aggrieved could theoretically sue and say, look, this is a meeting. And if the court finds that it is a meeting, realistically, first time around, what the judge is going to say is, don't do that again. And they might say, go get training, in which case you get to see me again. But if you're doing it after the judge says don't do it, or you do it in a situation where you definitely should have known better, then there's the possibility the judge is going to say, look, the municipality and possibly you, especially if you are acting maliciously, are going to be paying the attorney's fees and costs for the person who sues, which can get very expensive.
Got another question or comment. In many of our conservation districts, offices are in federal buildings and they hold meetings there. And right now there's restrictions on how many people can be in a room. So based on that, should those meetings be held in a place where those numbers are not restricted?
So I guess just to be realistic, if nobody shows up to your meetings except your board members, I wouldn't worry about it. But if you have some really, controversial issue or something people really want to weigh in on, then I would suggest that you find a different venue. And it's going to be something you're going to have to determine at kind of the local level. And if there's a situation where, you didn't anticipate it being controversial, but you have like 50 people show up and that exceeds the cap, you're going to have to reschedule it for a different time. And so you just have to be flexible while those restrictions are in place.
Thank you.
I had
There's
a question about email usage.
Sure.
If you're making the emails public or submitting them to the public as meeting notes, how would that be defined? How would that be viewed?
So you mean that you're exchanging emails between board members and then making those emails public? Is that your situation?
Right.
I would stay away from that. You know, because the problem is the right to know law is written, requires the public to be able to attend the meeting. And how on earth are they going to attend a situation where you're emailing somebody else? I've had very fancy or people who are very technologically savvy talk about kind of fancy systems where they could exchange that information live on the municipality's website. And I guess theoretically you could come up with some sort of technological solution that complies, but I don't know what it is and I haven't seen it yet. So I'd stay away from it.
It seems a little unclear as to how you would even get anything done outside of a meeting if you can't use email. So I'm trying to really, this is something that I struggle with here on our Conservation Commission, because right now we're only meeting monthly and we're coming out of our Zoom meetings, and I'm not as worried about it, but other board members seem to be extremely worried that any sort of email is off limits. And I can't really wrap my head around that as a young millennial.
All right. So let's break this down a little bit. So for example, the things that are prohibited, you have to have a majority of the board communicating about an issue. So for example, if we have a 5-member board and, I'm the chairperson and I email to everyone some information and people start replying with substantive emails, replying all, that's where you're going to have a violation. The other situation is where you have a series of emails between individual members where you eventually have a quorum learning about what's happening. And so it would be like, I email you and say, hey, this application before us, or, we're talking about buying this parcel. I think it's a good idea. What do you think? And you reply. And then we say, well, what does Paul think? And then I'll say, I email Paul, and then Paul gives me a response. Then I let you know. And, as I said, if we have a 5-member board at this point, now we have 3 members who know what's going to happen. That's a violation as well. But what you can do is you can assign people tasks. So, you could say, Nate, we need information about, whatever it is, the application or something. Can you go deal with that? And you have to have more than one person to be committee, right? So you can just tell someone to go do that. If they go do it and report back to the board at a public meeting, you can do that. You can also have, I think you can probably have, people kind of work on things, but not have really the majority of the board. I'm trying to think about this in a way, like you can have people like do parts of the project, but you can't bring the project together until you're at a board meeting. And unfortunately, that's just the way the law is written. So it makes it government slow and inefficient.
That's helpful. Thank you.
Yep.
I think we have just one more, and then you can take a break. After this question, you can continue your presentation and then take a break again for questions when you have a logical breaking point, Nate.
Mhm.
Can you just clarify if a local listserv counts as a public place for posting your meetings or for other purposes?
I don't think so. The law is, you have to remember who is writing the law. The people who are in the legislature generally aren't as technologically savvy as many board members at the municipal level. And they're not often in favor of technological solutions. So, you may have something where everybody in the community receives an email. And I know that happens in some communities, but I don't think that would count as a public place. I I think your safer bet is using some traditional public place like, your town hall, your library, or your post office. And there's also that exception for your municipality's website.
Thanks. All right, then we'll continue. And when it's a logical breaking point, we'll take more questions. Thank you, Nate.
Sure. And I see that there's a question about, if you're all working on a trail. So yeah, you should definitely advertise that. Anyone who shows up, put them to work. I mean, that's what I would do. But I guess, if you're going to be discussing kind of board business there, it's hard with conservation commissions just because, you have this role within the town. And I think maybe if you just stick with what your role is within the town, not necessarily things that are outside of that, like trail maintenance. And as long as you're not discussing things that you would discuss at your public meeting, I think you're probably okay there with qualifying that as an other encounter, unless you're desperately trying to recruit people to work on the trails with you. And then they're in the woods, and who's going to complain? You have more witnesses than they do. So all your meetings have to be open to the public. And that is really the key, whether we're talking about, email as we just were, or any other situation. And that means that the public has to be able to show up and be able to hear it, or otherwise ascertain what's happening. And they have a right to record that meeting as well. So I can receive a fair number of questions about that. And in the context kind of a normal meeting, hopefully the people who show up are kind of your average citizens, or at least reasonable enough that you can talk with them. And if they want to record it, you can say, look, you can put your phone here on the table, or whatever the case is, so you can get good audio. And as long as it doesn't interfere with board business, that's fine. And it is a little bit of a negotiation, because there are people who are going to show up and try to hold their phone in your face, and hopefully they'll be reasonable, and you can deal with that. But that's just a little bit of dealing with people. Because you're on a public body, as you might imagine, you're representing the public, and so the public has a right to know what you think about things. So you can't vote via secret ballot. And kind of as an aside to that, when they don't like what you do, they don't have a right to protest at your public meeting unless you give it to them. So a public comment period is not required at a public meeting. It obviously is at a public hearing, because that's the definition of a hearing. The public can come in and tell you whatever their opinion is about the matter. But as far as a meeting goes, it's up to you to set the limits. And I think probably the most enforceable limit and the most reasonable limit, and the one that you should seriously consider before you have a situation, is a time limit. So somebody can come up and speak for 3 minutes or 5 minutes or whatever you want the amount of time is. And then after that, you cut them off. And you have to apply that evenly across the board. Because if you wait until there is a problem, then you end up in court, because the problem is the person shows up, they hate what you're doing, they're complaining about you, they upset board members, eventually someone cuts that person off, and then they go to court, and the judge was not in that situation, and says, look, there's this thing called the First Amendment, and then you end up being chastised. So instead of waiting for that to happen, implement your time limit that would reasonably accommodate anyone who has something to say to the board, and then enforce that equally. And that's not to say, if somebody comes up and says, look, I have this piece of property that I want the Conservation Commission to buy, like I'm really interested in having it conserved. It's not to say that you can't then schedule them for, add them to the agenda or something like that and say, wait, we need to hear more about this than what we're allowed to hear in 3 minutes. It's not to say that's not possible, but in terms of that public comment period, generally, that's what that time limit is, what you want to focus on. So let's talk a little bit more about electronic communications. As I mentioned, you really want to avoid substantive discussions. So, if you're the chairperson, you send out the email to all your members, and, I receive it and I say, look, I can't attend the meeting, that's fine. If I can say, I can't attend the meeting, can you hold or I'm going to be late to the meeting, can you hold the vote until I'm there? I should arrive at, 7:30, so I'll be half an hour late. That's probably fine too. What I can't say though is, I really think this is a dumb idea and I'm totally against it. And I want to be there when the vote happens. And so I can vote against it, because at that point, we've now had a substantive discussion of whatever it is that's before the board. And you also have to keep in mind that there is a provision in the right to know law that says you can't circumvent the spirit and intent of the right to know law, otherwise that's a violation. So that was my, description earlier of our sequential emails. And realistically, I think the best way to email information out to your board is, if you don't have a staff person, is to blind carbon copy everyone. So what I would do is I'd send the email to myself, and then I'd blind carbon copy all of you. And that way, if any of you decide to hit reply all, it only comes to me. So I'm the only person who sees it, and that's less than a quorum of the board. And the other thing to keep in mind is emails are governmental records. And this is something that municipalities are struggling with right now. It is something that has gotten into the courts, and I think is probably going to get more involved in the courts. So the one case we have so far is from this year. And what happened is basically what I predicted would happen, which is that a former municipal official left the employment and association with the municipality, had some emails relevant to whatever the right to know request was in her personal email. And the requester said, I know that this person has emails, and the municipality has an obligation to preserve governmental records and turn those over as the requests are made. And the judge actually said, okay, municipality, you have to go talk to this former official and ask if she still has those emails, and if so, ask her to turn them over. And that, I think, was a very nice way of doing it, because I think when this is a more serious situation, which you're going to have, some sort of horrible facts on, the court is going to say, look, here's a court order seizing this person's email and requiring, whatever, the lawyer for the municipality to go through it, or maybe the court or a court appointed officer to go through it to obtain these records. And that's going to be a big problem, but it's not a problem that is unpredictable. So here's my suggestion for all of you. If your municipality does not give you an email address, and my recommendation is, if it's possible for your municipality to do so, they should do so. But it's not possible for all of them, because there are so many boards and there's some very small municipalities, they just simply can't afford that kind of IT bill. So if they don't give you an email address and you can't reasonably obtain one, get an email address that's just for your municipal business. And so you just use it for that. It's totally separate from your personal email address. And so, you direct people as they want to email you. And so if there's ever a situation where for some reason the municipality needs to look through your emails to find something, or you might have it, or there's a court case, you don't hand over your personal email address. You just hand over the municipal one. Then you can still email everybody you want to email, and you don't have a situation. You've kept that separate, and it also protects you, because at some point in time, you're going to want to retire to Florida or whatever. You're going to be tired of working with the public, and you can just hand the keys over to somebody at the municipality. And if you're in charge of a municipality, I tell you, look, at some point in time, people are going to start handing you the keys. They're going to hand you the password and the login for their email address. And it's going to be, you know, Nature Grays Conservation Commission at, you know, whatever. And you're going to have to figure out what to do with those records and how to deal with those. And statutorily, there is a records committee that's created under RSA 33-A, and that's something that records committee should be considering and talking about. All right, I always get questions on that bit of advice. So does anyone have any? Oops. I'm not seeing any. All right. So as I've definitely emphasized here, avoid the temptation to use inaccessible technological options during the pandemic and any other time. You know, we're just trying to maintain normalcy now. And I know, you know, just looking at the map that gets updated and just the calls I'm getting from members, everybody's doing things differently. Some places are totally in person, no restrictions. Some places, everyone in town still wants to wear a mask, and there's a whole range. And I was out and about New Hampshire last weekend, so I know that is still the case. So you just have to work with what you have, but try to just kind of maintain what you would ordinarily do. As far as minutes go, there are some minimum required contents for minutes. Importantly, minutes cannot be recorded; they have to be written out. That's not expressly stated in the statute, but that's, you know, how it functions when you read it. And so minutes have to contain the names of the members, people appearing before the body, a brief description of the subject matter, any final decisions, and the names of any members who made or seconded each motion. And that's it. It's really an art, writing minutes. You could have it very, very brief, or you could have it more detailed. In any case, you have to have them ready within 5 days. Doesn't mean they have to be the final minutes. You could just have the minimum required contents. And then, you know, if you're one of those boards that wants to have a transcription, you can send that out and have that done. And that's what the board will approve. But there's no requirement to approve minutes. So, you know, you can certainly take your time with that. And you can also, you know, certainly use any sort of recording to assist the minute taker in making the minutes, but it's not a substitute. All right, let's briefly talk about non-public sessions here. So it's a non-public session, not a non-public meeting. You know, the world, according to the Right to Know law, is divided into two things: meetings and non-meetings. And then at meetings, you either have a non-public session or just your ordinary public meeting. There's nothing else that the statute allows for. It used to call non-public sessions executive sessions, but that has gone by the wayside. These are exceptions. They're not the rule. So realistically, it's stuff that you want to keep out of the public view, and for good reason. Probably the one that's most relevant to what you do as a conservation commission is the purchase of real property. And it's pretty logical why there'd be an exception there. Because if you tell everybody, hey, we have $15,000 to, you know, purchase some property, then you're in a situation where everyone who has property that meets whatever specifications you're looking for is going to be listing it for $15,000. Whereas if you don't tell them how much, you might get a better deal. And so that's really the purpose. Unfortunately, that's sometimes hard to explain, as simple as it may seem to the legislature, as I had to do this past legislative session where they really wanted to gut that rule. And I'd explain, look, you know, the consideration of a board to look to purchase property is really something that they need to be able to do outside of the scope of the public seeing them. There are other things here. I don't think most of those are relevant to you, But in the interest of time, I will mention one other one, which is the reputation exception, because for some reason, every board gets hit with this, which is that someone says, hey, can I meet with the board in a non-public session to discuss something that would affect a reputation? So just to be clear, it's totally up to the board whether to meet in non-public session, and if they do decide to do so, who to invite in. Totally up to the board. And as far as the reputation goes, it has to be something that's going to negatively affect someone's reputation. So the best example actually comes from the statute, which has to do if someone's poor. If someone's poor, that's something that the statute assumes is, or I guess the legislature assumed when they wrote the statute, is going to affect their reputation. So if they, come to the select board and they are looking for an abatement because they can't afford their taxes, that's something that can happen in non-public session, and similar things along that line. So it has to be something that's going to affect their standing in the community generally. It can't just be, something they say that's really dumb or would reveal them to be really dumb. That's not going to affect their, that's not something that's going to qualify. It has to be something that's going to negatively affect their reputation. It can't be the reputation of someone on the board. It has to be someone outside the board. To enter non-public session, you have to make a motion. The motion has to state the specific exemption that's being relied upon, and the vote has to be a roll call to enter non-public session. And we actually have a guide to that. If anyone needs that, just contact me afterwards. I'm happy to send that to you. It's like I think a 2-page document about how to enter non-public session and what happens in there. But basically, you keep minutes just like you would for public session, except that you also have to record any actions so that the vote of each member is ascertainable. You can say, if it's a 3-member board, 2 for, 1 against, Gray's against, that tells you the other 2 members are for it, or you can do roll call votes. I think boards are pretty split on this. A lot of them at this point are doing roll call votes just because it's easy to remember and keep things straight. As far as the non-public session goes, you can make any decisions that you need to make in non-public session. And there's actually no provision in the statute about how you return to public session, but there is a provision that says you can only seal the minutes for non-public session in public session after you've had the non-public session. So realistically, what you have to do is vote to leave non-public session. And if for some reason someone thinks that one of your board members thinks that the reason for entering non-public session is not valid, they can object, and their objection would be noted in the minutes. And as far as deciding whether to seal those minutes, the minutes have to be publicly available within 72 hours, unless the board determines by a 2/3 vote in public session that one of these 3 exceptions would exist. And generally, it's going to be render the proposed action ineffective. As far as sealing the minutes, realistically, the best way to seal the minutes is just to seal them. It's not to have any sort of triggering event, although there is now, or will, I don't know if the governor signed it, but there will shortly be a provision related to the real estate transaction exception, which would essentially have an automatic triggering event when closing happens, which makes sense. So, you're going to purchase the property after you've had closing. Doesn't matter what your discussions were prior to closing, because it's too late for anybody to do anything because you've already had closing. So that just makes sense. It's a little caveat that might make things a little bit harder for municipalities to keep track of, but it makes sense. As far as other considerations you might want to think about for meetings, whether you're going to have a non-public session, is that something you often have? If it is, and you post an agenda, are you going to post that on the agenda, or are you just going to say something like, this board may enter 1 or more public sessions as the need arises? As far as when you're going to have that non-public session, much like when you're going to have the public comment period, just think about when you're going to time that. And just keep in mind that only board members are obligated to keep what they learn at non-public session secret. So if you invite some random person in and they decide to go out and tell the newspaper whatever happened, they can do so. There's nothing you can do about it. I was actually at a board meeting where, for whatever reason, the board entered non-public session for two separate reasons. Had the first reason go through, they discussed everything. They assured the person that they were going to seal the minutes, and then after the meeting happened, the second person who was in there went out and talked to the reporter that was in the hallway, and it was in the news the next day, and that was quite a problem for everyone who was on the board. So I do want to briefly touch upon governmental records because there are some things that are relevant to what you do. But does anybody have any questions on that overview of public meetings?
Yeah, we've got some questions. One should minutes include members' names and how they voted?
So they should include all the members who are present at the meeting. As far as how they voted, you only have to be able to figure out how someone votes if you're in a non-public session or one or more members are participating remotely. Or I guess if you call for a roll call vote, but those are the only situations.
Okay, another question. Are public bodies required to publish agendas so that the public knows what business will be discussed?
There's no obligation to publish an agenda. I know many boards do, but there is no obligation to do so.
And last question, for real estate purchase, should the vote to seal say unsealed at closing?
Because that's going to be the law shortly, that makes sense. As you know, what the law says is the minutes for a non-public session can only be sealed as long as there's reason to seal them. So at that point, there's no reason to keep them sealed afterwards. So you can unseal them at that point. Generally, in other situations, I'd say just say those minutes are sealed, and then when someone makes a right to know law request for those minutes, essentially what will happen is whoever handles that at the town is going to come back to the board and say, is this something you can release or not? And you as the board, under another new provision of the right to know law, which again, I'm not sure if the governor signed yet, is going to be able to enter non-public session to discuss non-public session minutes and determine whether or not to unseal those minutes. All right, so let me very briefly summarize some governmental record information for you. So a governmental record is also a public record, and it's any information created, accepted, or obtained by or on behalf of the public body, board, or a public agency in furtherance of its official function. So it's not a birthday card because that's not in furtherance of its official function, but it is something like, if you have plans for the whatever the parcel is, that's going to become a governmental record. Governmental records also include electronic information. So those emails we talked about, voicemails, text messages, digital recordings, etc. Those are all governmental records, which is why I cautioned you to create a separate email account for any governmental business, because you want to be aware of that. And there are certain retention rules under RSA 33-A:3A, which pertain to how long you have to keep records based on what they're categorized as. But this is something that boards are running into a lot, is they're getting these electronic records and they're not keeping them as they should be. And unfortunately, this is an area where there's a lot of interest from people who are interested in knowing how the government is keeping its records. But there are a couple things that are not going to qualify as governmental records, and those include preliminary drafts. So imagine a situation where we're on a board together and you say, Nate, go write a letter to the governor to, have us look at it at our next meeting. In that letter, we want you to say A, B, and C, and that's going to result in, us getting money for one of our purposes. So I go and start writing that draft. And of course, we discussed that at a public meeting. And so, someone out there in the audience says, well, I want to see that letter. So they make a right to know law request. Well, until that letter has been given to a quorum of the board, it qualifies as a preliminary draft, and therefore it's not disclosable, which of course makes sense because, it may be the case that it takes me several sessions of sitting at my computer to write the letter and sending it out preliminarily before it's ready for review by anyone is just going to confuse the world, and that doesn't make any sense. The other exception is personal notes. So if you take notes at a public meeting for your own personal use, those are not going to be subject to disclosure. Now, if you do introduce them to the record, so for example, you're taking notes about what's happening at a meeting, and at the next meeting, there's a discussion with the minutes, and you say, no, the minutes are incorrect. Mr. Jones said X, and we wrote down Y in the minutes. And somebody said, well, how do you know that? And you say, well, I have it in my notes. I wrote down exactly what he said. Well, now you've introduced those into the public record, and they're going to be disclosable. So just be careful if you do so. And lastly, recordings of meetings by the board or on behalf of the board are not required to be made. I know there was a little bit of confusion about that at the beginning of COVID. Hopefully there isn't anymore, but they're not required to be made. If you do make them, you only have to keep them for as long as it takes you to write out the minutes. You don't have to keep those recordings forever. You can throw them out, and if the request comes in the next day, too bad, the record doesn't exist. But if you do keep it for some reason, you do have to disclose it if it does exist. And so we'll get to the violations here. So there's no enforcement agency. It's just any aggrieved person who's going to sue. And there are a couple provisions, RSA 91A7 and 8, that are the remedy provisions and the provisions that allow the lawsuit. I guess most things are going to go in the order that I described earlier, which is most of the time the judge is going to shake their head and be like, don't do this again. And that's an injunction. They may say, go talk to NHMA or somebody else and get some training because, this really shouldn't happen again. But if you're doing things that you shouldn't be doing, and it's pretty obvious to everyone, that's when you really run into trouble. That's when it's going to start costing you some money personally. But if it's something just generally bad, but not specifically attributable to any one member of the board, then it may be the town that's paying for that instead of you individually. But the good news is there is a flip side. So if someone is suing the board for whatever reason, because they hate the board and they don't really have a good reason, the board has been complying with the right to know law, the court can actually find that the lawsuit was brought in bad faith, and therefore bar the person from bringing suit again, as we've seen in a couple situations, as well as require that person to pay the town for any costs that were incurred due to the lawsuit. And with that, I'm 2 minutes over time, but it was pretty close to an hour. So any final questions?
We've got some in the queue here. I think you answered one. What is the consequence if a request for minutes is ignored for an undue time? I think you just answered that.
Yep, they're going to court, and you're in trouble at that point because the 5-day rule is pretty simple. So that's one that's gonna get the judge to yell at you.
One from Bill here is a draft motion on a matter before the body considered a record.
A draft motion before the body. Yeah, because so the body has seen it. So a quorum of the board has seen it. So that's going to qualify as a record.
Okay.
If it's something like you're drafting at home that, one other person on the board knows about, and you're going to present it to the board later, that's not going to qualify. But then again, no one's going to know that you're doing that until you present it to the board anyway.
Okay, here's another question. Must minutes be available in physical form, or is, for example, posting on a town website sufficient?
So that's where the law's interesting. So there's no requirement to approve minutes, but if you do approve minutes and your town has a website, then the website either needs to have those approved minutes uploaded, or it needs to have a posting that says where those minutes can be found. So that's what the law states. As far as whether they're in physical form or electronic form, either is permissible.
And one last question here is the natural resource inventory often goes through several drafts before it is final. Commission members review and comment on each draft. How much of this information is considered a government record?
Well, I'm hoping that you're commenting on the drafts at the public meeting, and all of that's going to be considered public record. So my suggestion is when you have draft documents, to stamp them draft, and if it's going to be something as multiple iterations, date it, or make it some indication of what version it is, so that when somebody obtains an earlier version and things have changed substantially by a later version, that it's clear why they're confused.
A new question has arisen. Can an automatic request for all minutes of all meetings be provided to the requester within 5 days, or is this done one meeting at a time?
No, you can, a requester has to can only request records that exist. So they can only request past meeting minutes. They can't request future meeting minutes.
Okay. Now, can another government organization have a standing order to get the minutes from different districts that it supervises?
Again, it has to be individualized. Well, okay. I mean, it's a individual citizen could only request on an individualized basis. As far as the government goes, government is different because it doesn't make right to know requests. All municipalities are subdivisions of the state. And if it's supervising these districts, presumably as part of that supervisory process, it can obtain information and records from those districts that it supervises. And that would be outside the scope of the right to know law.
Okay. Another question here. How far back do you need to keep minutes on record?
I believe, let me double check here, but I believe that it's going to be permanently.
Yeah, that's
Let's see. Meeting minutes are going to have to be kept permanently. That's correct. And that's under 33-A:3A.
Are there
All
any
right.
other questions?
Any other questions? Alrighty, well, thank you for having me this evening. You have my information, so if you have any questions in the future, do feel free to reach out. I'm happy to answer those for you. I certainly know that we went over a lot of information tonight, and based on my experience presenting on these things, at least a few of you will think in 5 minutes, oh God, I had this question and I forgot to ask. And so I'll expect your call tomorrow.
Nate, thank you very much.
Well, thank you.
Thank you very much. A couple of people have asked about the slides being available to them, and Dick Lutz did put in, if you would like a copy of the slides, to please send a request to this email address, president@nhacd.org.
It's .net, not .org.
Oh, I lied. Thank you, Jackie.
No problem.
Glad somebody's awake.
Thank you so much.
Good night,
Any last minute anythings? Or is everybody going to now go adjust their fan or their air conditioning or their windows?
Thank you all.
We should say that these will be posted, this whole event should be posted on the NHACD website for future review.
Yes, that's true.
Thank you, everyone.
Thank you, Nate.
Good night, everybody.
Good night,
Motion
everyone.
to
Thanks for
adjourn.
being here.